Welcome to this explainer on the foundational sources of English law. Okay, let's dive right in. If you're prepping for your AQA law exams, you are in exactly the right place. This session is designed specifically to give you the precise building blocks you need to succeed, breaking down what can feel like some pretty heavy history into clear, manageable steps.
So it's kind of the ultimate question for any Year 12 law student, right? Where does English law actually come from? You might picture this one giant, dusty rulebook sitting in a hidden vault somewhere in London, but the reality? It's far more fascinating. Rather than coming from a single document, English law is this highly complex, interlocking system built up over literally hundreds of years. Today we're going to uncover exactly who makes these rules.
Here's our roadmap for today. We're covering 1. Custom as the historical foundation. 2. Common law and judge-made rules. 3. Statute law and parliamentary acts. 4. Comparing murder and theft. And 5. How all these sources interact today.
Right, starting off with Section 1, Custom, the historical foundation.
A custom is basically just a rule of behavior that develops completely naturally within a community until it just becomes the accepted norm. Think back to after the Norman conquest. The king appointed these traveling judges, and they didn't bring some massive written rulebook with them. Instead, they resolved disputes based on the very customs that local communities were already following.
Now, while custom provided the crucial historical bedrock that eventually helped unify the country's rules, it is largely a thing of the past. For your exams, definitely remember that custom is a historical source. It's highly unlikely to create any significant new law in modern times simply because that job has now been fully handed over to judges and politicians.
Which brings us nicely to Section 2, Common Law, Judge-Made Rules.
As those traveling judges we just talked about went around applying the most reasonable local customs across England, they ended up creating a unified system. We call this common law. This unwritten law isn't drafted by politicians sitting in a room. It's literally born in the courtroom when judges resolve real individual disputes.
So how does this actually work in practice? Well, the core mechanism here is precedent. It happens in 3 steps. First, a relevant case goes to court. Second, the judge makes a decision on the important legal issue at hand. And third, and this is the absolute crucial part, that legal principle becomes a binding precedent. This means later courts must follow that exact same principle when deciding new cases with similar facts. It allows the law to develop gradually, just one single case at a time.
You are definitely going to need examples for your coursework, and these are some of the heavy hitters. Major areas of English law like involuntary manslaughter, negligence, and the rules of offer and acceptance in contract law, well, they were all developed through common law. But common law does have a major limitation. Judges can't just wake up on a Tuesday and decide to rewrite the law. They have to wait for a relevant case to actually come before them. This makes it a lot less suitable for making large or immediate changes across society.
And that leads us to Section 3, Statute law, parliamentary acts. Statute law is the written law formally created by Parliament. Unlike judges, who are totally restricted to the specific facts of whatever case is in front of them, Parliament has a wonderfully broad lawmaking role. They can proactively create completely new laws, they can tweak existing ones, or just repeal outdated rules entirely. And the best part? These changes immediately affect the entire country.
But creating statute law requires a very specific, formal process. A proposed law first has to successfully navigate the complex parliamentary process in both the House of Commons and the House of Lords. Then, it culminates in receiving royal assent from the monarch. Only then does it officially become an act of Parliament and enter into force as statute law.
So why is this so absolutely vital today? Because society changes unbelievably fast. Statute law is incredibly useful because it allows Parliament to react immediately to rapid societal and technological changes. I mean, think about computer hacking, online offenses, or complex medical developments like IVF. The existing common law simply cannot adequately address these sudden modern dilemmas, so Parliament steps in and passes brand new legislation to cover them.
Moving on to Section 4, Comparing Murder and Theft.
To really cement this difference for your exams, let's contrast 2 major offenses side by side. On the left, we have murder. That's a common law offense, meaning its definitions were developed by judges over centuries. On the right, we have theft. That's a statutory offense, precisely codified by Parliament in the Theft Act 1968. Remembering this direct contrast is an absolute must for your exams. It hits the nail on the head.
Finally, Section 5, How the sources interact. The truth is, these sources don't just operate in total isolation. They are deeply, deeply connected in our modern legal system. Let's look at assault and battery. The definitions of these crimes originally developed as common law, but Parliament later stepped in with statutory legislation to set their maximum punishments under Section 39 of the Criminal Justice Act 1988. This perfectly illustrates how both common law and statute law contribute to the final rule.
Furthermore, the interaction flows both ways. Parliament might write an act, but let's be honest, sometimes the wording they use is a bit unclear, or maybe it's capable of more than one meaning. When a dispute over that wording reaches the court, it is the judges who must interpret the statute and decide exactly how those words apply to real-world facts. So, Parliament writes the broad rules, but judges actually apply and interpret them on the ground.
Take a quick look at this table to recap for your coursework. It's super simple. Common was created by the people, as our historical foundation. Common law is developed gradually by judges through individual cases. And statute law is proactively created by Parliament to make broad, formal changes.
English law is just this beautifully dynamic, interlocking system, and it leaves us with a genuinely fascinating final question to chew on as you continue your AQA studies. If Parliament officially creates the modern statutes, but it's ultimately the judges who get to interpret what those statutes actually mean in real life, who holds the true power to shape English law today? Think about that one. Best of luck with your revision.